So this one action Jackson shot is about the Seminole Tribe v. Florida, the 1996 Supreme Court case, the Seminole Tribe v. Florida. And what was decided in the Seminole Tribe v. Florida was that, well, the Seminole Tribe really had no rights. What the hell were they doing complying with the law? You had passed the Indian Gaming Regulatory Act, which is some Republican president in 1988. And the Indian Gaming Regulatory Act said that the state of Florida, any of the states that had the Native Americans, they had to have a good faith effort. So they passed this law that was essentially forcing Florida and the Seminole Tribe of Florida to sit down at the table to come up with to negotiate with the Native American tribes to create compacts govern Indian gaming. So, yeah, the Seminole Tribe is going to lose its case, and Florida is going to be victorious. So when it comes to sovereign immunity, this is just another, fucking legal shenanigans to fuck over the Seminoles. Once again, fucking goddamn William Rehnquist. Okay, so let's start from the beginning. This is about the 11th Amendment. So I want to cover, this is about the Seminole case, but I got several other court cases, the new ones that I'm talking about, that I'm going to go through the history of this, because unless you know the Supreme Court decisions, you don't actually know what the 11th Amendment means. You could read the 11th Amendment and then think that the words that are printed on the page is the 11th Amendment, but it turns out that's not the case. They're going to add sovereign immunity, Supreme Court case, Hahn's decision, 1890 Hahn's decision, when the entire, everything that we thought we knew about America crashed and collapsed on that day, when Hahn's v. Louisiana came down. So, the 11th Amendment actually is half wrong. The 11th Amendment prevents other citizens from other countries from suing the state that you live in, which is, okay, that's fine. I don't want a bunch of, Australian citizens suing my state. But there is actually some pretense that says that if my state had injured the Australian citizens, but I'm an American, I deserve all the rights and freedoms, and so therefore that's okay to me. That's fine to me to bar foreigners from suing your state. That, makes sense. Now, the other part to the 11th Amendment that I disagree with is that it bars citizens from other states from suing your state. So nobody, if you don't live in Colorado, you can't sue Colorado. That prevents all 49 states from suing Colorado. And it also prevents me, who lives in Colorado, from suing any of the 49 states. It doesn't matter if Colorado injured you. It doesn't matter if any of the 49 states injured me. The 11th Amendment says that citizens from other countries, citizens from other states, cannot sue the state you live in. And so therefore, the state that you live in, what the 11th Amendment did do, since it omitted the phrase, citizens cannot sue their own state, since they didn't put that phrase in intentionally, they had talked about it. Caleb Strong was the senator that put this forward. They had discussed adding that part, but it couldn't get passed because of obvious reasons. What do you mean the citizens of the own state can't even sue the state? So the 11th Amendment does two things. It bans two groups of people, and then by inference, it allows everybody else, right? So if we're going to say states from other countries, citizens from other countries, citizens from other states can't sue my own state, and then you just leave it at that, well, that sounds to me that citizens can sue their own state, especially since we're Americans and we're freedom-loving Americans. So the Supreme Court really shines when they get it right, okay? So the Supreme Court, they could just say we're the judicial branch, so we're the boss. But when SCOTUS gets a decision right, they not only nail down the current law, but they nail down a fundamental truth about the human condition. The 1954 Brown versus Board of Education, whatever dispute between Brown and the Board of Education of Topeka, Kansas, whatever they were going through, this case went ahead and solved it, went ahead and come up with the verdict. But in the 1954 Brown v. Board of Education, when they came up with the whole separate isn't equal, separate is inherently unequal. Once the Supreme Court of 1954 pointed out that segregation in public schools was wrong, that signaled to the nation that perhaps not just segregation in public schools was wrong, maybe segregation, period, was wrong. And that means the entire country needs to segregate. So the 1954 Brown versus Board of Education decision is cited by many as being the beginning of the Civil Rights era. Once the highest court in the land had said that segregation in public school, and in this one case, wasn't good, then everybody, so that's, the Brown versus Board of Education said, what are you guys doing? Why do you have an apartheid system? Why are you doing things like Israel? You're separating people, you're saying they got to live on this side and others got to live on that side, and of course, they got to live on the wrong side of the tracks, right? So the 1973 Roe versus Wade decision, this is a nice, fair, and balanced approach to abortion. Congress hasn't passed a law to top Roe v. Wade. Because, you got to be pro-choice, pro-life, you got to be one or the other. The Roe v. Wade decision was fair and balanced. You can get an abortion in the first trimester, you cannot get an abortion in the last trimester. And then the states could fill in the blanks. Tinker v. Des Moines says that we have the right to freedom of speech as students, public school students, even though you're under 18 and therefore have no contractual authority. When you go to public schools, you still have a right to free speech. That was the armbands for the Vietnam War. So you're allowed to wear armbands for any reason because of the Tinker v. Des Moines case. Also, so the Tinker decision was right, therefore eternal. And then so is Marbury v. Madison. As long as governments form themselves around three branches, judicial review will always be a thing. Yes, of course, the judicial branch should be the one that tests the constitutionality of the executive and legislative branches. So the Supreme Court shines best when they get the decision right. The Supreme Court, when it comes to the 11th Amendment, they shine best in the 1793 Chisholm v. Georgia decision, and in the 1821 Cohens v. Virginia decision. And then the Supreme Court fails in the Hans v. Louisiana decision. So just quickly, because the history of this thing, the 11th Amendment does not, specifically say citizens cannot sue their own state. So the Hans decision is going to assume a doctrine of sovereign immunity that isn't there. They're going to say the 11th Amendment was leaning towards sovereign immunity. Let's just go ahead and give it, complete sovereign immunity. Alexander Hamilton wrote it in that one Federalist paper, so let's just, go along with it. Who gives a fuck? So 1793 Chisholm v. Georgia decision is a great decision by the John J. SCOTUS Court. Alexander Chisholm needed to get paid by the state of Georgia. He was acting as an executor or as an executive, as he was the executor for the estate of Robert Farquhar. So Robert Farquhar was the actual person that gave the goods to the state of Georgia to fight the Revolutionary War, but he never got paid. Alexander Chisholm takes over his estate after Robert Farquhar dies, and he sues the state of Georgia because the state of Georgia owed him money. And the Supreme Court decision, they decided, well, the state of Georgia owed Alexander Chisholm money, then you need to pay state of Georgia. And so that's the 1793 Chisholm v. Georgia decision. This is an important decision because this is what inspires Caleb Strong to file the 11th Amendment. So the 1798 11th Amendment is passed 5 years after the Chisholm v. Georgia decision, and the 11th Amendment is half wrong. And then 1821, you got the Cohens v. Virginia case. So notice how all these are versus the state. You're not allowed to sue the state. This is what, the Hans decision is going to say is you can't sue the state. You have sovereign immunity. The state can do no wrong. You have no way to redress any grievances if the state commits it. So in Chisholm v. Georgia, Georgia needs to pay Chisholm. In Cohens v. Virginia, this is not them suing, this is actually them, they're bringing up a lawsuit in federal court because they said that there was a conflict of laws between the federal and the state law when it comes to lottery tickets. according to Cohen brothers, two Cohen brothers, who lived in Virginia, and they sued Virginia in federal court because they said the federal law allowed them to sell lottery tickets, but the state law said no. So you had two Cohen brothers in Virginia who sued Virginia, and they upheld that decision, and that decision came after the 11th Amendment. So the Cohen's decision, that interpretation is my interpretation of the 11th Amendment. It's really any free-thinking person would see that that's the case. Now, after the 1821 Cohen's v. Virginia case, you got the 1890 Hans v. Louisiana case. Now, Hans v. Louisiana is when the world came crumbling. It just came tumbling down. This is, essentially 9/11, Pearl Harbor, and Nagasaki all combined. This is the Iraq War genocide and the Vietnam War genocide and the Yemen genocide and the genocide in Myanmar. This is all those combined. Okay, so the 1890 Hans v. Louisiana decision, again, we're suing the state, right? So you got Chisholm v. Georgia, Cohen's v. Virginia, now you have Hans v. Louisiana. And what's Hans v. Louisiana going to do? This establishes the modern doctrine of sovereign immunity. So Hans bought Louisiana state bonds. Louisiana changes the Constitution. Hans fears he's going to get fucked over because of the constitutional change. He sues Louisiana in a federal court, alleging breach of contract, which is protected by U.S. law. It's in the Constitution. It's in the Article 1, I think. So the right to contract is an American right, and they cannot be abridged for any reason. We all have a right to contract. And so that means you have a right to agree to a set of terms and conditions by another person. And so that's what he's suing on, right? You got all these federal laws, and here they're sitting there saying that Hans, v. Louisiana, they're sitting there saying that Hans isn't allowed to sue Louisiana. Yeah, he bought Louisiana bonds. Yeah, Louisiana stole, changed the Constitution, so therefore made those bonds worthless. Louisiana fucked Hans over, and the 1890 Supreme Court isn't going to do anything about it. So the Hans decision, it doesn't fuck up as much as I said before, but it fucks up everything about the 11th Amendment that could have been worthy of saving. So the 11th Amendment was half wrong in 1798. It was half wrong because, yes, the foreigners, citizens of Botswana and Barbados and Romania and Russia, I don't want the citizens of foreign countries really having much standing. Now, there might be some, exemptions to that, but I think that's a good general rule. The citizens of Canada can't clog up our court systems with their bullshit, unless we are doing something specifically, something lobbing, grenades or some shit, I don't know. But ultimately, I think that part is okay. The citizens of Canada, no, you cannot sue Colorado. The citizens of Texas, Tennessee, Nevada, Oregon, Washington, California, the citizens of all the states in the country should be allowed to sue Columbia or Colorado or Georgia. All the citizens in all the 50 states should be able to sue all of the 50 states in the Union. And, throw out the frivolous cases. Fuck frivolous cases. But if you actually have an injury, the state actually did something to you, you need to have a legal remedy in order to, come back. So the whole idea of sovereign immunity, I think, is really a bullshit notion. There are some instances where I could see a citizen of Canada, needing our court system. Maybe we could have our own specific path for the citizens of foreign nations to be able to sue. But to block American citizens from suing other states, that cuts our citizenship by, substantial margin. Technically, I look at the 11th Amendment and I'm allowed to sue Colorado because of it, but because of the 11th Amendment, I'm not allowed to sue 49 other states. So the 11th Amendment cut my citizenship in half. In 1798, the 11th Amendment was a half wrong. It was, halfway wrong. But after the Hans decision, the 11th Amendment then became 100% wrong. So the Hans decision did fuck everything over. It makes the 11th Amendment an absolute evil fucking thing. Sovereign immunity, right? Oh, yeah, it was always there. What do you mean? Read the Constitution. Read between the lines. Yeah, I read free cheeseburgers, motherfucker, so you're going to give me my free cheeseburgers? The Supreme Court's going to make shit up. And a quick note, the only reason I think Kentucky's not a good litmus test, because if Matt Bevin wins in Kentucky, it says nothing. What a popular governor of, Republicans, he does shit for the Republicans, even though the one populist almost beat him, but he might become more populist now, I don't know. So if the people of Kentucky don't vote for, if they do vote for Matt Bevin, that says nothing. Of course they're going to vote for the Republican. They are all Republicans. The few people that vote, even the Democrats are Republicans. They voted for Hillary Clinton. It's a very right-wing, ultra-right-wing state. Only 10 to 20% are voting, and those 20% of the voters are right-wing as fuck. They've been voting for Mitch McConnell for, 57,000 years. They love Mitch McConnell. They can, Kentuckians just cannot get enough of Mitch McConnell. They just love that man. They love him like crazily. Not they don't follow his cases, or they don't know what he believes in or what he stands for, but they know that he has power, and so, that resonates with sycophants. But in England, if Boris Johnson wins, that's going to do something to America. If Jeremy Corbyn wins, that's going to do something to America. So that's a fair fight. Jeremy Corbyn versus Boris Johnson, that's a fair fight. Whereas Andrew Beshear versus Matt Bevin, that's not a fair fight. It's in Kentucky. It's right-wing. So if Andrew Beshear is able to topple Matt Bevin, that could signal, a great change. I think that would say something, that a, staunchly Republican state just threw out their staunchly Republican governor. That says something. But if Matt Bevin wins, that says nothing at all. If Boris Johnson wins, that says something in the snap election, and if Jeremy Corbyn wins. So I think the UK election, anyways, that was just a little quick aside. So back to the Ex parte Young decision in 1908. So, 1908, you got the Ex parte Young decision. This is a good decision in regards to sovereign immunity, made, considering that it was made in the shadow of the Hans decision. 1890 Hans decision says that, the states have sovereign immunity. Citizens can't sue their own state, other states. They can't sue no states. The state is supreme. They get it all. So they have sovereign immunity. That's a right protected by U.S. law. You just have to, get behind it. Well, not exactly, but the 1908 Ex parte Young decision, they say that it's okay to sue the individual public officials, but not the state itself. So I could sue Jared Polis, but I can't sue Colorado. That's what the 1908 Ex parte Young decision says. It's a good decision because it, pokes holes in sovereign immunity. I'm not for sure, though, why railroad rates can't be regulated by the state. Is it because they cross state lines, so therefore only Congress can regulate because all Minnesota was trying to do in this Ex parte Young decision was make sure that the railroad companies were charging reasonable rates. And then, I guess, they're not allowed to regulate them, and then the Attorney General, because he was enforcing the laws that they passed, they said that since he was enforcing an unconstitutional law, and not as his position as an Attorney General, but as a criminal who had just gone hog wild with power. And they're going to throw Edward T. Young, the Attorney General of Minnesota, in jail for contempt because he believes that the 11th Amendment is as the Hans decision said it was. So he listened to the 1890 Supreme Court case, and they interpreted the 11th Amendment as giving sovereign immunity to the states. And then when the Edward T. Young goes into federal court and says, you can't sue me, I'm part of the state. The 11th Amendment says you can't sue me. And then they're like, no, we can sue you. We can issue an injunction against you, and we can sue you. What are you going to do now? So, even though they're defending the high, powerful, corporations, the railroad corporations, and let's assume that they're correct on it. Let's assume that interstate commerce somehow allows railroad companies to not have to listen to the laws of the state. They have to listen to the laws of the federal government, but that's not the state. If that's the case, then because they were defending these big corporate conglomerates, they actually poked a hole in state sovereign immunity. So I like the poking the holes of the state sovereign immunity. The actual case itself, this might be a bad case. It might be a reversal. I feel like I would have sided in principle with Minnesota because they're allowed to regulate the rates. But unless, the Commerce Clause, I need to know exactly how the Supreme Court came down on the Minnesota, the railroad, them charging the railroad company, or not charging them, but just saying you can only charge this much. So they were stopping price gouging. They weren't bankrupting the railroad companies, just making sure that they weren't, going above and beyond. So you got Rufus Wheeler Peckham, that's the justice for the 1908 SCOTUS decision. You got the Northern Pacific Railway, that's the railroad corporation that's in question. Then it's the stockholders. The stockholders are actually going to sue both the railroad corporation, their own company, the Northern Pacific Railway, in order to prevent them from abiding by the law, and then they're going to sue the Attorney General of Minnesota. So they're suing their own people and they're suing the other people. So that's kind of fucking genius. To set up a corporation and then to make it look like it's the citizens of the country. The citizens are standing up for the people. It's the citizens that's saying, Edward T. Young, you need to be constitutional. It's, it's the shareholders of a corporation. And so that means the citizens of your own state and everybody's state gets to sue whatever states they want to sue because of this loophole. So the loophole is just you can sue the individual state officials such as the governor, the Secretary of State, the Attorney General themselves, but not the state. So Jared Polis can be sued for, matters between citizens and the state, but the state of Colorado cannot be sued. Okay, so again, by this time, after the Hans decision, this is just such a clusterfuck of a law that anytime that there's anybody that goes back to the idea that we did not have sovereign immunity, that's the correct direction. The 11th Amendment, the Constitution, sovereign immunity is not written anywhere. If the founders and the framers intended for sovereign immunity to be a part of the law, then they would have wrote those words. But because we are fighting against tyranny, we got the three branches of government. It seems to me that on principle, freedom-loving Americans would not want any entity to have immunity. We all got to abide by the rule of law. And so if you give immunity to anything, give immunity to McDonald's, give immunity to, the Mother Teresa, give immunity to whoever. If you give immunity to anybody, then that's essentially saying, do as you please. You can do no wrong. No matter what you do, nobody can do anything to you. So I don't believe that sovereign immunity was a part of the Constitution nor the amendment. It doesn't make any sense. The 11th Amendment only was half wrong, but then the Hans decision made it 100% wrong. Now we're in no man's land. Now we're in this big cluster fuck town. So common law isn't in the Constitution either. Sovereign immunity, common law, these are not inside the Constitution because they meant for the words to be in the Constitution to matter, and that's it. So the 14th Amendment exemption, you have Fitzpatrick v. Bitzer, Fitzpatrick v. Bitzer. The Fitzpatrick decision, 1976, Fitzpatrick v. Bitzer. They said in the Fitzpatrick decision, 1976, that the 14th Amendment, you could sue the state or file a lawsuit against the state. You get to abridge their sovereign immunity when it comes to matters under the 14th Amendment. The 14th Amendment just says due process. All the states have to have due process and essentially protect the privileges and immunities of all the other states. And so since the Bill of Rights dictates the freedoms of all of America, they've opened up the 14th Amendment to guarantee due process rights for all of our freedoms. And so that's actually a good insert, the federal government. If the state of Colorado isn't protecting your right to religion or to peacefully assemble, to petition, to speak, your freedom of the press, your right to bear arms, or your right to not have soldiers coming into your house, that's the Third Amendment. We have a lot of rights. We got 50 rights and freedoms. So the 14th Amendment says you must have due process. And then the Supreme Court ties due process in with the Bill of Rights and the rights and freedoms of all Americans. So therefore, the federal government can stick their nose. They can sue a state if any of those rights and freedoms are abridged due to the 14th Amendment exemption. So, again, the Hans decision, fucked up the whole world and said that sovereign immunity does apply to all the states. All the states in America get to get away with all their crimes. The Ex parte 1908 Ex parte Young decision says, you can't sue the state, but you can sue the state officials. The Fitzpatrick v. Fitzpatrick v. Bitzer decision is the 14th Amendment exemption. So they have sovereign immunity, but since the 14th Amendment was specifically written to abridge sovereign immunity, then there's a 14th Amendment exemption. So where it's necessary to enforce the rights of citizens guaranteed under the 14th Amendment, the court had held that the Congress can abrogate state sovereign immunity pursuant to its powers under the 14th Amendment, which clearly contemplates limiting the power of the states. Now we go to the Pennsylvania v. Union Gas Company decision in 1989. This says the legislature can enforce the Commerce Clause in the states. So you got a 14th Amendment exemption, you got a Commerce Clause exemption, a Commerce Clause exemption, a 14th Amendment exemption, and then you can also sue the individual state officials. So Justice Brennan in the Pennsylvania v. Union Gas Company, Justice Brennan was joined by 3 other justices in asserting that the 11th Amendment was nothing more than a reflection of common law sovereignty that could be swept aside by Congress. In Pennsylvania v. Union Gas Company, it said that Congress could abrogate sovereign immunity under the Commerce Clause. So that's, essentially they just sweep, common law sovereignty under, the rug. They throw the state sovereignty, complete immunity under the bus. So the Pennsylvania v. Union Gas Company is in the right direction, right? So now we have a Commerce Clause exemption. Now, you have, let's see, I didn't really get to the Seminole Tribe at all, did I? You have another decision here, Alden v. Maine, and the dissent for Alden v. Maine is brilliant. So I guess I'll just label this, fuck the 11th Amendment, number 6. And then get into the Seminole Tribe v. Florida. I was going to go through it quickly, and then I had a couple of these smaller cases. So Alden v. Maine is going to be passed in 1999. It says that the legislature of the national government doesn't have the power to sue the states. So we're going to go back to sovereign immunity. This is a 5-4 split decision. So, it's not totally one way. This is 1999. This is going to be 3 years after the Seminole Tribe v. Florida, after the Rehnquist decision. So the Alden decision is totally wrong. The probation officers from the state of Maine wasn't getting paid for their overtime work, so they sued the state of Maine, and the state of Maine employed the probation officer, so therefore they sued their employer. And the Supreme Court said they weren't allowed to do that. So therefore, the state of Maine can break the Fair Labor Standards Act. They can ignore the Fair Labor Standards Act. You're not allowed to sue Maine in federal courts to make sure they enforce the Fair Labor Standards Act. They didn't pay their probation officers the overtime work that they were due. And so, therefore, the state of Maine fucked over their probation officers. I think it's totally right and proper for them to sue, but the Supreme Court in 1999 disagreed. So they say, the 11th Amendment. No, the 11th Amendment does not protect sovereign immunity. The 11th Amendment doesn't protect sovereign. It says that it's okay for citizens to sue their own state. The Alden decision said that the Fair Labor Standards Act being applied to states couldn't be upheld by federal court. So therefore the states can just ignore the Fair Labor Standards Act if they want to. So you got a commerce exemption. You have a 14th Amendment exemption. You could sue the state officials themselves, but you cannot sue in defense of the Fair Labor Standards Act. You have to, basically give up the fair. Why did we even pass the Fair Labor Standards Act if the federal courts wasn't going to back their own goddamn law? Just some of this shit just makes you wonder.